Good afternoon. My name is Mark Rosenblum. I'm the Deputy Director of the U.S. Immigration Policy Program here at the Migration Policy Institute. And I want to thank you for joining our webinar today on unaccompanied child migrants in the United States. How are they faring? Attention has returned to the issue of unaccompanied children in recent weeks as the number of children arriving at the U.S.-Mexico border increased from 3,800 in June to 4,600 in August. This is the largest number of UACs apprehended in the month of August, at least since 2009, and likely since the early 2000s. Attention is also focused on unaccompanied children in recent weeks because of the hundreds of thousands of refugees from Syria and elsewhere in the Middle East and Africa arriving in Western Europe. It's important for Americans to keep this much larger flow in mind when we describe the thousands of children arriving at our borders as a crisis. Having said that, it has been a significant flow over the last 2 years. Our webinar today provides additional insight into this phenomenon by focusing on Central American kids who have arrived during that period, beginning during the peak period of the surge in 2014 through the summer of 2015. We have 3 great presenters to cover this issue for you. Sarah Pierce is a research assistant here at the Migration Policy Institute. Sarah is the author of a policy brief MPI released today that goes through the data on where children are settling, how they're faring in immigration court, and what kinds of services they get in U.S. schools and communities. Aria Summers, the Advocacy Director at Kids in Need of Defense, which represents unaccompanied immigrant and refugee children in their deportation proceedings. Aria will describe in greater detail some of the challenges children face in getting access to legal counsel and the very different kinds of experiences they have in immigration court depending on whether or not they have legal representation. And our third presenter will be Annie Wilson, the Chief Strategy Officer at Lutheran Immigration and Refugee Service, which helps migrants and refugees successfully resettle in U.S. communities. Annie will describe some of the challenges UACs face and what LIERS has learned through their work with unaccompanied children around the United States. First, let me go over a couple of quick housekeeping notes. I want to remind you that the audio and PowerPoint from today's webinar will be available on our website later today at the first link that you see. And the report, Unaccompanied Child Migrants in U.S. Communities, Immigration Court, and Schools, is available on our website. You can see the second link that you see on your screen will direct you directly to the report. If you have any technical problems during the webinar today, please email events@migrationpolicy.org or call 202-266-1929. The best browsers to access the webinar are Google Chrome or Firefox. And if you have any problems hearing via the web, you can dial in using the call information that we sent you via email. And finally, I want to say that we will have a Q&A at the end of the call. There won't be a voice Q&A, but you can type any questions into the chat box on the right side of your screen, direct your chat questions to the host, or email questions to events@migrationpolicy.org. And you can go ahead and send those questions as soon as you have them, and then we'll get to them at the end of the call. So with that, let me pass it over to Sarah Pierce. Thank you.
All right, thank you so much, Mark, for the introduction. So first, I will be discussing where these children have been placed within the United States, then how their immigration court cases are progressing and what the outcomes of those cases have been. Finally, I'll review the limited services available to these children, including their access to public education. Just 2 notes before I start. If you see the acronym UAC, that's referring to unaccompanied child migrants. And the data, as Mark said, that I'll be going over is from the start of fiscal year 2014 through the latest available data in fiscal year 2015, which is up until August 31st, 2015. So first, what we see here is a map showing unaccompanied child migrants who have been placed with sponsors represented by circles, and already existing state-level concentrations of foreign-born populations from the Northern Triangle countries of Guatemala, Honduras, and El Salvador. We set up this contrast because the majority of these children are from these 3 countries. While many of the unaccompanied children who have arrived at the border are also from Mexico, under current law, most Mexican children are immediately deported, while children from non-contiguous countries have the right to stay and contest their deportations. these children are transferred by Border Patrol into the custody of the Office of Refugee Resettlement that is responsible for processing and sheltering the minors who are simultaneously placed into removal proceedings. The vast majority are then released by the office into the care of a parent, relative, or family friend in the United States while they wait for their case to progress through the U.S. immigration court system. So you can see here that the children who are largely from the Northern Triangle countries have mostly been placed in areas of the United States with already high levels of foreign-born populations from the Northern Triangle countries, with just a few outliers. Next, how are their immigration court cases progressing? First, I think it's important to note that the majority of unaccompanied minors who are showing up for their cases. You can see here that of cases initiated since the start of fiscal year 2014, thus far, child migrants have failed to appear for just 15% of these cases. But the influx of cases have created a difficult situation for the already overburdened court system. In July 2014, the Department of Justice implemented a priority docket to push these cases ahead of other cases in immigration courts. However, the priority docket has failed to resolve the situation. As you can see here, 65% of UAC cases which began during fiscal years 2014 and 15 remain unresolved. In addition, the priority docket has increased the backlogs for other types of cases to the point where individuals with immigration court cases now wait an average of 1,071 days for their first hearing. You'll notice here that we have two categories of relief, labeled informal and formal, and that the majority of those migrants who have received relief received informal relief. In fact, if you're just looking at the population of migrants who received relief, 97% received informal relief. The difference between these two labels is whether or not the child has received immigration status upon completion of their immigration court case. What we label as formal relief occurs when the child receives a simultaneous grant of immigration status before the judge at the end of the case. On the other hand, under informal relief, the child's court case has closed or terminated, so the child no longer is in active removal proceedings, but the child has not received a simultaneous grant of immigration status from the immigration court. Many of these children do immediately or eventually receive a grant of immigration status, such as asylum or special immigrant juvenile status from a separate agency, the U.S. government's immigration agency, U.S. Citizenship and Immigration Services. So while some of this informal relief population remains unauthorized, some of it does not. Meanwhile, even though most children are appearing for their cases, the large majority of removal orders have gone to children who have not appeared for their cases, and many of the removals have gone unexecuted, meaning that at least some of these children are likely to be remaining in the U.S. in unauthorized status. We examined three factors that play a large part in determining the outcome of children's cases. First is whether or not the children appear for court. Of those who show up for court, we can see here that 78% receive some form of immigration relief, whether it is formal or informal. Meanwhile, if they fail to show up for court, for the most part, judges must order such in absentia respondents removed. Thus, considering the large portion of those who show up that receive relief, it seems likely that many of those who have been ordered removed in absentia would have been eligible for some form of relief. Next, whether children have an attorney also plays a very large role in their case outcomes. As reflected on this bar chart, children with attorneys receive immigration relief at much higher rates. In fact, children are 9 times more likely to receive some sort of immigration relief if they are represented by an attorney. Whether or not they are represented by an attorney also plays a large role in whether or not the children show up for court. Between fiscal year 2014 and August 31st, 2015, 93% of UACs who were not represented by counsel failed to appear for court, compared with only 23% of those with representation. Third, we examined the location of the cases, which does seem to have an effect on case processing times and outcomes. This slide shows total UAC cases initiated since the start of fiscal year 2014 with green shading, and the portion of those cases that are still pending, indicated by the percentages. As we can see, immigration courts in different states take varying amounts of time to process UAC cases. This can be for a variety of reasons, including varying practices relating to granting continuances among immigration judges, the number of judges in each court that hear UAC cases, and the backlog the court had prior to the priority docket. Certain types of immigration relief that require at least partial adjudication by state and local agencies also create differences in processing times and the treatment of the cases across states. For example, different ages of majority among state juvenile courts have created barriers for youth trying to obtain special immigrant juvenile status in some states. Next, I'm going to talk briefly about the services available to the unaccompanied child migrants, including public education. As we saw on an earlier slide, since the beginning of fiscal year 2014, the Office of Refugee Resettlement has released over 77,000 unaccompanied minors to communities throughout the United States. And because U.S. law guarantees education for all youth, regardless of immigration status, this population is entitled to free public elementary and secondary education. Other than anecdotal reports, there's a real dearth of information about how many of these children are actually attending school and where they are going. Anecdotal evidence suggests that school districts across the country are having disparate reactions to this influx of new students and the additional costs. For fiscal year 2015, Congress did provide an additional $14 million for local education agencies in areas with large influxes of unaccompanied minors. But by some estimates, this would only come to about $233 per student, leaving the majority of the financial burdens on local schools. In the wake of this, one issue we've seen schools struggling with is how to serve older students, whether it's best to place them in K-12 education or adult education. And their reactions in general have been varied, from creating programs with services tailored to the newcomers to the other extreme of creating barriers to enrollment entirely, such as requiring stringent documentation upon enrollment. Because they're in an authorized status, unaccompanied migrants are eligible for very few public services other than K-12 education. The Office of Refugee Resettlement offers some post-release services, but these are limited to very few migrants, under 10%. For services such as healthcare or legal representation, unaccompanied children must depend on proactive service providers, localities, states, or federal programs that create services to meet their very specific requirements. The result is a real patchwork of services. For healthcare, even though they are ineligible for federal health insurance, some states have expanded some healthcare coverage and services to include income-eligible children, regardless of immigration status. For legal representation, as we reviewed earlier, legal representation can be one of the most important factors in case outcomes for unaccompanied minors. Thus, some public and private institutions have stepped in to provide legal counsel. Despite this, the majority of UACs still lack access to legal services. And with that, I will turn it back to Mark.
Great. Thank you, Sarah. I'm going to now pass it to Aria Summers from Kids in Need of Defense. Before she starts, let me remind you that you can go ahead and send questions if you have them through the chat function on the right-hand side of your screen. Direct your chat questions to the host, or you can email questions to events@migrationpolicy.org. And Aria, thank you.
Great. Thank you very much. First and foremost, I'd like to thank MPI for inviting us to speak on today's panel. And I will be speaking about access to counsel, the current framework and key challenges, and explore some of the perspectives on different positions of unaccompanied children in the system, those who are represented, unrepresented, the in absentia cases, and child capacity concerns. In terms of the access to counsel framework, we have pro bono federal, state, and local programs. On the federal side, HHS and DOJ both fund programs for access to both direct representation attorneys and pro bono programs where attorneys mentor private sector attorneys from law firms and in-house counsel to represent children in their proceedings. On the state side, we've also seen involvement. California has funded attorneys to provide direct representation to unaccompanied children in their state. And on the local side, we have also seen support from cities like New York and San Francisco to direct funding for representation for unaccompanied children. Philanthropy has also responded to the urgent need last year by also funding nonprofits across the country in their efforts to represent children on a pro bono basis in immigration proceedings. And I'd also like to note, although private immigration attorneys do not receive federal funding, they also play an important role, not only serving as private immigration counsel, but many have also participated in taking on pro bono cases in their caseloads. And yet, despite this framework, in 52% of the cases today, based on track data, children do not have counsel. So what are some of the limitations or challenges that we're facing? First, in the program, some of the federal programs, there are some limitations based on the age of the child. So for instance, in Justice AmeriCorps, children have to be less than 16 at the time that the notice to appear is filed. There are also geographical limitations. So there may be places in the country where there are no programs that are funded, and there may be few attorneys who specialize or have expertise in representing children. Next, we have children's perspective themselves about the legal systems. So here in our immigration context, children are placed in the same proceedings that adults face, and oftentimes do not understand completely the nature of the removal proceeding, their rights and responsibilities, and they often come from countries where rule of law systems are not functional, adding to the dilemma. Next are attorney resources, training, and ethics. So in addition to the fact that there may not be enough attorneys in a particular area to cover the need for all the children, and children could be on wait lists for various programs, representing children is not an easy task. It is complicated and often requires more holistic lawyering, understanding child development and capacities, and also knowing child-specific standards to push for in legal cases. And finally, geographic factors. For instance, in some places, like children in Alabama, will have to travel to Georgia to appear in immigration court, which can make representation complicated and costly. Next, we turn to represented children. So finding an attorney in and of itself is a challenge, and sometimes a child may be waiting for a referral within a particular program. But once you have an attorney, the attorney needs to prepare the case appropriately, working with children who may need psychological support, and takes time to build trust. Children find it very challenging, as many of us do, to share humiliating, shameful, and fearful experiences. And so this adds to the time frame needed to prepare cases. There may also be language challenges, particularly with Indigenous children. You have to remain up to date on constant changes in immigration law for children, and ethically you need to know how to represent children to ensure that they participate in decision-making in the immigration proceeding. Also, the forms of relief. USCIS, in the vast majority of cases, is processing the petitions, and there is an appellate process. So to give you an idea of time frames, SIJS in some jurisdictions, even to complete the family court portion, could take 6 months to a year, but sometimes a lot shorter. There is a 180-day maximum to adjudicate an I-360, and there is additional wait time for adjustment of status. For asylum, it also takes time to prepare. An interview could come between 3 to 6 months, and decisions can come anywhere between 2 months to a year. The current T visa processing time is 9 months. The U visa processing time is 1.5 years, and for VAWA, it's 5 months. In fiscal year 2014, 11,610 children applied for SIJS and asylum. This does not include the UT and VAWA cases. So in these cases, a judge may grant a motion to terminate or dismiss while the child has petitioned before USCIS. In addition, motions to terminate or dismiss could also be related to underlying due process challenges in the actual proceeding. And this really serves to protect the integrity of our justice system. And finally, with respect to prosecutorial discretion, ICE may be in a position to exercise this in the case of children who are represented. With respect to unrepresented children, they are also facing challenges in finding attorneys, and they may not be able to find an attorney within the allotted timeframes before the immigration court. For unrepresented children, the greatest concern that I'd like to identify is child capacity. So child capacity is really the child's ability to make a decision within a given context, and that can be impacted by the various factors such as intellectual and cognitive disabilities, mental health disorders, and child development. And this connects to legal competencies, their factual understanding of a proceeding, a rational understanding or appreciation of the proceedings, their ability to consult and assist counsel, and decisional capacities. So how does this play out in an immigration context? So in a master calendar hearing and pleadings, it may sound simple, but during pleadings, a child would need to be able to understand the immigration charge, their due process rights, and defenses to that charge, in addition to the possibility of filing for relief. For individual hearings, a child on their own would have to refer to a complex area of law, areas of law that are highly litigated, and really understand how it applies to them and gather evidence. And finally, I'd like to turn to the in absentia cases. So in these cases, ICE initially files the notice to appear with immigration court and has to provide notice to the child, and in certain cases to the parent or legal guardian. In the context of the surge, and with the implementation of priority dockets for both children and families, this process came under significant strain. Many attorneys and legal services organizations across the country are concerned that service of notice and where notices were filed may have contributed to the in absentia rates. The 21-day timing of priority dockets may have also caused children to miss hearing dates and perhaps not even know about their hearings. And limitations on access to counsel may have also contributed to this. Once a child has an in absentia order, it becomes necessary for the child to file a motion to reopen, a very resource-intensive process that requires knowledge of immigration and case law. And finally, child capacity concerns, as I mentioned in the prior slide. In terms of efforts to respond to in absentia cases, EOIR has indicated that their LOPC programs have conducted outreach, and many attorneys and legal services organizations across the country continue to be very concerned about this group of children and what we can do to help identify children eligible for relief and ensure that their cases are heard and properly processed. Thanks very much. I'd like to pass it back to Mark.
Great. Thank you, Aria. And we'll now turn it over to Annie Wilson from Lutheran Immigrant Refugee Service.
Great.
Immigration and Refugee Services, excuse me.
Oh, nice save. Hi, good afternoon, everyone. It's a real pleasure to be here, and I just want to express really strong appreciation to MPI, both for all of the effort that went into creating this report and for hosting this webinar today and really helping to advance an understanding of what's going on for unaccompanied children who have arrived over this most recent period. During my remarks today, I'm going to be focusing on some findings and recommendations that are drawn from a few reports. The first was developed by my organization, Lutheran Immigration and Refugee Service. It was released in July 2015, and it's available on our website, lirs.org. And this report was drawn out of a series of roundtables that we did with practitioners and people who are engaged on the legal service side, on the policy side with children, including my esteemed colleague to my side here, Aria, who spoke earlier. The other two reports were collaborations that we did with some universities, the first of which is also available through our website, and the second is forthcoming, so should be available soon. But before I turn to some of the findings and recommendations from those reports, I want to take a moment and just go back in time a bit. Lutheran Immigration and Refugee Service has been engaged with the challenging issue of unaccompanied minors arriving in the United States from Central America, frankly, for decades at this point. We were probably involved with the parents of some of the young people that are arriving now. And a lot of those earlier arrivals were coming to join parents who themselves were refugees in the 1980s and during that period of intense conflict in Central America. And the challenges that those families faced, the challenges of poverty, the challenges of lack of immigration status because asylum was largely denied to all of that population, and the challenges of integrating into a lot of urban communities where a lot of these Central American kids were really facing a lot of hostility. They were living in the midst of violence. And in many ways, what we see right now is that we're sort of reaping the results of some real failures to address integration in that earlier wave. So I just want to highlight how important it is that you know, we collectively address this challenge more effectively this time around. However, one of the most critical problems that we face in looking at the social service side of what's going on for these kids and their integration into the United States is that there is a tremendous lack of data about what is going on with these kids. To date, there has not been any kind of comprehensive tracking of child welfare and of the social circumstances of kids after they leave the custody of the federal government. There is, starting in this federal fiscal year, which began on October 1st, there will be some telephone follow-up that is been mandated by the Office of Refugee Resettlement and will be carried out by, as I understand it, some of the caseworkers who are employed by the shelters where the kids reside temporarily before further resolution of their situations. So there will be at least some follow-up for these kids, but up until now, there really hasn't been. So that's a huge issue, is that we actually just don't know what happens to a lot of these kids. And many of them are going into family situations where they've been separated from family members for many, many years. They're coming out of situations of trauma, and they have a lot of needs. And many of them are also at risk from the very situations that they fled in their home country, where there are, you know, connections that cross borders that could still be an issue for these young people. For a very small number of kids, under 10%, there are some post-release services made available by the federal government to provide some extra support and case management for some of these kids. It's typically limited to about 6 months of follow-up. One of the challenges there is that our fantastic staff of social workers that works in the LIRS Children's Services Department has noted that a lot of the family breakdowns start to happen at about the 6-month mark, when the honeymoon of reunion is over and some of the real tensions of family life start to kick in. So that support, you know, sort of happens during the period of time when, ironically, the situation is still relatively stable for many of these kids. One of the things that the report that was carried out by the School of Social Work at the University of South Carolina found is that geography is everything in terms of the services that are available for kids. So if these young people, children and youth, are lucky enough to go into a community that has really mobilized a lot of services and resources, the kids will tend to do better. But many kids go into areas or communities where services aren't available, and in those cases, there is just a real challenge for these young people. So the fact that there's not a comprehensive approach for these kids is a really serious issue. Because of the lack of data that has so far characterized this whole area, we've partnered with the University of Maryland and have started to do some tracking of some of the cases that have not received post-release services to understand better what's going on with that population. So these were not cases that were flagged as being in jeopardy, needing extra care, needing extra attention. This study was done in 2 tranches. One was looking at 100 young people, mostly of tender age, under the age of 14. The second study is focused on some of the older kids. One of the things that this intervention discovered is that the very fact that these people were getting follow-up phone calls asking, for example, you know, have you attended a legal orientation presentation, or do you know if your case is with EOR, that it actually really upped the statistics for this study population of those who had that. But the dearth of that kind of participation early on was indicative of how confused people are and how really challenging it is for this population. So for the younger kids, there was some relatively good news that most of the kids were in school by 1 year in. About half of them had legal aid at about 12 months, which was close to the number that had a court date, so that was pretty good for these younger children. A number of them had health concerns. That really dropped away by a year in, but only 63% had accessed medical care after a full year in the United States. And then this last bit of data, LOPC is a legal orientation presentation for targeted at the sponsors, typically parents for this younger group, and 61% of those sponsors had no knowledge that this was available at 14 days. And thanks to many phone calls asking at different intervals, 30 days, 60 days, 6 months, 1 year, by the time that it finished, most had at least heard of it, if not as many had accessed it. We've had a lot more, the researcher has had a lot more trouble to date with the older youth, and that part of the study is also not complete, but it shouldn't come as a complete surprise that for these older youth, that the situation is much more unclear and in some cases more fragile. So many more of these are not necessarily heading to their parents, but are going to more distant relationships. Many of these young people really are anxious to work or are pressured to work, and so are not in school or completing their education, and a lot of them are simply not willing to speak to somebody doing follow-up research or cannot be reached. A good number of the young people are no longer with the original sponsor by the time some of the follow-up calls are coming in. This is also an age group where some of the family breakdowns are more prevalent because of the challenges and tensions of adolescence. So let me just finish with a few recommendations that are pulled from the many, many, many recommendations that are included in the LIRS report that I mentioned earlier. So first of all, we recommend that there be a continuum of post-release services for every young person after they are released from the custody of the federal government, so that, you know, every child receives at least some follow-up. And I would say along with that, that it's really critical that this population be tracked so we actually do have a better understanding of what their social issues are, what their mental health issues are, and how they're faring, because we can't really design appropriate follow-up if we're not even tracking them to understand what their life challenges are. Secondly, it's really essential that there be improved coordination between the federal agencies that have responsibility for this population. And in fact, we need better information sharing across the whole system. So communities that are doing an effective job, particularly schools, which is one of the few services that is available to all of these young people. There's some really successful school programs. More information needs to get out about that. And national, local information sharing is really also essential. And then we would, and you know, there's more details about this, but we would recommend some strengthening of the school-based and community-based services for this population. So, thank you very much.
Thank you, Annie. So if you'll go down one more slide, then you'll show people where they can send questions, reminding you to send questions using the chat function on the right side of your screen, directing questions to host, or you can email questions to events@migrationpolicy.org. And I'm going to just quickly take the first question, because we got one question that's a very big picture question on what has caused such an increase in unaccompanied child flows over the last year. And everybody around the table has been doing research on this. We have a report on our website that we published in April that goes into, you know, explores that question in depth. I'll just very briefly say that, you know, this is a complex mixed flow. Kids leave Central America because of extreme violence in all three of the Northern Triangle countries, extreme poverty in those countries, political instability, which has been acute recently in Guatemala, and there are also pull factors in the U.S. Most of the kids who are leaving have families in the U.S. The inefficiencies in U.S. immigration policy and the long delays in the court system means that cases are not being resolved quickly, and people perceive that as the ability to stay here. And then one of the most important factors in the last few years has been a huge increase in the kinds of services that immigrant smugglers are offering. And the smugglers are also really promoting incorrectly that children are generally permitted to stay here. But we've seen that those smuggler services are a real shift just in the last few years. So those are all factors that contribute to that, and I would refer you to, you know, all of our websites, including a report we published in April to get more on that. And then another set of questions that we've gotten focuses sort of on the process, and one question is that I think I'll direct to Sarah, is why are these kids sent to the Office of Refugee Resettlement since they're not necessarily refugees? Why is ORR the key actor under the TVPRA?
Yeah, I mean, under the TVPRA, ORR has been given this responsibility, which in some respects is appropriate since ORR is connected with a network of organizations across the United States that deals with this and similar services. I don't know if Annie has anything more to say on that.
Yeah, I mean, just to go back a little further in time, the responsibility for the care and custody of these kids was at one time in the hands of the Immigration and Naturalization Service, which was a department under, which was a office under the Department of Justice. And when the Department of Homeland Security was created, a number of advocates felt very strongly that having the very part of the federal government that was working to deport these kids, that it was not, that it created some internal conflicts of interest for them in being able to also address the child welfare issues and the care and custody of these kids. And so at that time, the custody was transferred by law to the Office of Refugee Resettlement. And the Office of Refugee Resettlement has now for a number of years had a broader mandate than simply resettled refugees because it is also dealing with victims of trafficking. It deals with survivors of torture. So it has become the federal office with responsibility to address the needs of migrants at extreme risk and in need of some form of protection. So that's kind of the history.
Great, thank you. So we're getting a lot of questions about children who don't show up in immigration court and the different reasons that people may get in absentia orders, and also questions about, you know, the share of removal orders that are successfully executed. So, so let me, I think probably each of you, or at least a couple of you, may have thoughts on that. So, one question is, who is responsible for children who don't show up in immigration court, including if their sponsorship disintegrates, if they lose contact with their sponsor, and then also the question of the percentage of deportation orders that are successfully executed. Sarah or Aria, do you guys want to?
Do you want to start on that first half? Or?
Sure, I'd be happy to. And Annie, also, please feel free to jump in. So this is Aria, just addressing the question on the in absentia. I think both Sarah and I addressed the different reasons why children may end up with an in absentia order. So in terms of responsibility for showing up in immigration court, the way our system is structured is such that the notices go to the children. So children are ultimately held responsible, and they will pay that price for not showing up in court. And this can include children, you know, as young as 5 and 6 years old. So when we talk about children, we're including extremely young children as well. So ultimately, that responsibility rests with the child. There are responsibilities by the parent and legal guardian, of course, as well as the ORR sponsor to the greatest extent to facilitate that the child appears in the proceeding. So I think that unfortunately our system, because of the way it's structured, we don't have anyone who really accompanies that child in the proceeding, and that's one of the challenges of the access to counsel issue. If we had attorneys, I think we'd have greater appearance rates, particularly with these vulnerable kids.
And then as far as how many of these removal orders are going unexecuted, it's a difficult thing to know. We don't have exact data drawing a line from the removal order to whether or not it was executed. What we do know is executed removal orders for unaccompanied migrants has consistently been much lower than the amount of removal orders that are occurring. So for example, in the report, we note that in fiscal year 2014, over 13,000 minors were ordered removed, and this is cases that were initiated in fiscal year 2014, and then during that same year, only a little over 1,800 minors were actually deported from the country. So again, there's not necessarily a straight line between those two, but that difference has occurred for the last few years. For example, for cases initiated in fiscal year 2013, over 5,000 unaccompanied children were ordered removed, but in that exact year, only 1,800, a little over 1,800 again, removals occurred. So because of that difference, it looks like quite a few of these removal orders are going unexecuted, which we can assume that in absentia orders are largely to blame, but again, we can't draw that direct line.
And another question we got about children removed is whether some of these children are coming back to the United States Again, that's not something that we can directly measure. One thing that I can say is that we've also begun looking at the experience of kids who are returning, who are deported or otherwise returning to Central America, and what kinds of services are available to them in the region, and we'll be issuing a report on that next month. The short answer there is that children face difficult conditions when they are returned to Central America, and one of the innovations in the smuggling model is that the smugglers offer multiple tries. So some of those kids likely do attempt to re-enter the United States. Let me ask, we've gotten a few questions about the mental health needs that the children confront. How are their mental health needs met? How are they faring, given that high levels of kids have experienced extreme trauma, prior to their migration or during their migration? Are they eligible for Medicaid?
Hi, this is Annie. I guess I'll take that one. Yeah, it's a great question because I'm sure, as the person who posed the question knows, this is a population that has a pretty high need for mental health support, and the services are not widely available for these kids. There is no comprehensive, federal program that these kids can access. On a locality basis, there may be services available, but there also have been some creative models. Some of our local partners of Lutheran Immigration and Refugee Service have been trying to provide some more community-based support of peer groups for both the kids and their parents, who equally face some real challenges in dealing with suddenly very changed family dynamic, and in meeting the needs of young people who may have been through some really very difficult circumstances, even either in their home country or in transit, or even after arrival in the United States. So it's an area of significant need, and the response, as in meeting so many of the other needs of these young people, is pretty patchwork.
We're also getting some questions about the different treatment for children versus family units that arrive. One question: are we noticing problems with children being separated from families at the border, and whether some of the unaccompanied children attempt to arrive with family and are separated? And then another question about what kinds of services are available for families, what kind of experiences are family units having, and how they differ from the experiences of unaccompanied children who arrive on their own. Anyone want to take that one up?
Well, this is Annie. Let me address one thing about the families. I mean, what's unique about the kids is that, due to a combination of legislation and court action, there is a system in place for the unaccompanied children that attends to their care and custody up to the point of release. So it includes sort of the assistance with placement and so on, they're in the Office of Refugee Resettlement is housed in the Department of Health and Human Services, so there's a sort of humanistic approach to their needs. In contrast, the families that arrive to the United States from Central America, 95% plus of whom pass these preliminary legal hearings for credible or reasonable fear, 95% plus are being found to have such fear. These families are being sent to these new major family detention facilities, most of them in Texas, in the region outside of San Antonio, Texas, a small number going to a facility in Pennsylvania, and a very small number going straight from the custody of the Customs and Border Protection because of individual circumstances, they're not going in, but most of the families are going into detention, so it's a really strong contrast. After they have those hearings, most of them are being sent wearing these GPS ankle shackles up to communities, largely following the same geographic distribution pattern that you saw earlier in Sarah's presentation. The services for those families, there's the same paucity of services for these families as there is for the children, but the challenge of legal representation is even harsher for the families than it is for the kids, because there's been concerted efforts by organizations like KIND to really try and address the challenges of the unaccompanied youth and kids.
We have another question here. Are we going to see any legislative action in Congress that specifically addresses unaccompanied children? Is there likely to be action on this in an election year? And if so, what might that action look like? I'll note that there were a flurry of proposals last summer when these numbers first began to surge, and most of those proposals sought to roll back in various ways the protections that unaccompanied children currently enjoy, generally to put Central American children more or less in the same sort of fast track for deportation line that Mexican children are in, or to create a new sort of limited judicial proceeding that would allow children to be deported more quickly. None of those proposals saw real legislative action last year before that session of Congress ended. I know, Sarah, you've been tracking legislation, so I'll ask you to speak to whether what kind of proposals you've seen people talking about, and then we can speculate about where they might go.
Yeah, honestly, the only legislation I was going to bring up was that legislation which would have rolled back the TVPRA recommendations. I haven't seen anything recently in the discussion, so my hunch is if this issue was to come back up, it would be that again.
Yeah, and then just one other legislative issue that we're following is that the Obama administration has requested $1 billion to support the Plan for Alliance for Prosperity in the Northern Triangle, which is a comprehensive development strategy that the 3 Northern Triangle countries jointly developed that includes sort of employment creation, targeting the regions of their countries that immigrants tend to come from, infrastructure, rule of law, and counter narcotics. There's 4 pillars to the plan. The Obama administration requested $1 billion to support that plan. Both of the House and Senate appropriations subcommittees responsible for State Department funding have included smaller amounts of money to go to Central America, with the House focusing exclusively on sort of law enforcement and counter narcotics, and the Senate also proposing to provide infrastructure and economic development funds. But you know, we're following that in the appropriations process, but as people know, the appropriations process has been a little bit unpredictable in Congress in recent years. So you know, with or without an election coming, that's hard to predict. We've also had a few questions about how to talk a little bit more about how the children who are going through court proceedings, how they're faring long term, and maybe to explain a little bit more clearly what informal relief consists of, and the difference between asylum and special immigrant juvenile status, and sort of the broader category of informal relief. So, Aria, maybe you would take that.
Sure, of course, I'd be happy to. Thanks. So this is Aria. So the category informal relief, as described in the report, refers to cases that have been administratively closed or terminated. And that means the child doesn't have an active case before an immigration judge. So I think that piece is important. This comes from the track data. This does not necessarily include the children who are seeking relief before USCIS. So, for instance, with special immigrant juvenile status, which is a humanitarian form of protection for children who've been abused, abandoned, neglected, or something similar under state law, and cannot be reunified with one or both parent on account of those grounds. Those cases go before a state court process, and then a petition is filed with USCIS. So in some of these cases of informal relief, it may be that the child is in this process, and the case may have been administratively closed, or if the I-360, which is the SIJS petition, has been approved, the case may have been terminated, and the child may have that status and then would pursue adjustment of status before USCIS. So that's one type of relief that could be falling into that category, where an immigration judge does not actually grant relief in those cases. It's a separate process outside of our immigration courts. The second example is asylum. For children, they will apply for asylum before USCIS. So an immigration judge may administratively close a proceeding while the child is seeking asylum before USCIS. An asylum would be based on a fear of persecution. It's quite a complicated area of law. There are 5 protected grounds, and children from this region are generally seeking asylum based on gang-based violence, gender and sexual-based violence, and child abuse and domestic violence. Those are some of the most common cases that we see.
So we've had a few questions about geography, and Annie mentioned geography is everything. I wonder if Sarah or any of y'all could comment on, you know, some of the different experiences that follow based on where kids are placed, including the extensive sort of additional legal support and other support that New York City has provided children, and if you could comment on, you know, differences that you see, you know, at least anecdotally in different types of school systems, but to talk a little bit about the geography.
Sure. So I think one good example of kids who just really benefited from geography would be Montgomery County, Maryland. In their public school system, we've seen a huge effort to utilize both existing and new programs to help these children integrate into their system. And I should also note that Montgomery did receive one of the largest influxes of students. But some of the programs that they've really extended to these children include bilingual parent volunteers to help families navigate the school system. They also created an entry-level job skills program for Spanish-speaking students who are a bit older and who likely won't receive a high school diploma before they turn the age of 21. And those are just 2 of the examples of programs that they've extended to this population.
Here's a question that maybe, well, somebody will answer. As an attorney, many of these children have no relief available, so how do I, as an attorney, help them by representing them when all I can do is admit the allegations with no form of relief? Many attorneys decline representation when there is no relief. And then a related question is that many of the older children are reluctant to show up in court or reluctant to seek relief.
Okay. So this is Aria. I think that that question is really critical. What do I do when I interview my client and I can't determine relief? So before I even get to that, because that's really an attorney question, you really want to ensure that you've done all that you can to really reach that child. Working with these children, as we've all addressed, who have fled violence in many cases or have lived really in marginalized situations, have difficult journeys and have gone through a process here in the U.S., they may not share information the same way that we expect children in the U.S. to share, who have been educated about their rights and to be free from abuse. And so I think that we really want to push ourselves as attorneys when it comes to representing children. And there are lots of great resources from Kids in Need of Defense, the American Bar Association. A number of different organizations have published resources on how to really gather information from a child client in this scenario. And then ultimately, if you do end up with a client where there is no relief available, you've had due process, and the child is going to return, As Mark has mentioned, they are doing research on repatriation and reintegration programs. So if the child is going to be returned, there are programs available. Kids in Need of Defense has a Guatemalan child return and reintegration program as well, to which referrals can be made, and children from certain geographical areas can be supported in their reintegration. So it's really important to talk about these issues with your client before you get that removal order. That's the preferable way. There's also a child advocate program that's operated by the Young Center, and if you feel like it's not in the best interest of your child client to return, I would suggest contacting them and get their perspective on how you can incorporate best interest into your work.
So we're right at about 4 o'clock. I'm just looking to see if anybody wants to share a parting thought. We have actually, unfortunately, a lot of unanswered questions, but I know we're running out of time.
I guess I would just like to circle back, this is Annie, to the remark that you made in the opening, Mark, which was to consider what's going on in Europe right now and the kind of response that we're seeing there to the influx of refugees from the Middle East and from Africa, and to consider how very, very similar the stories are of this population of both the unaccompanied children and these families, and to contrast the kind of reception that they're getting here in the United States, and the lack of a really comprehensive approach, compassionate, caring, and protection-centered approach that we have here. And I think I would just urge everyone who is in a position to raise their voice to make a difference in U.S. policy to go ahead and do that, because I think that, you know, our country can do better.
I'd just like to add as a closing thought that I think for us, first and foremost, these are children, and that we really want to think about children's rights within this context and the access to counsel and what a positive impact that has on this population.
I think those are excellent closing thoughts. I think the one thing I would add is this report does point out a lot of issues about how the system is not working properly. I think a lot of that correlates with the fact that we have this influx of population, but not an influx of resources into the existing infrastructure, especially when you look at the immigration court system. Great.
Well, I want to really thank all three of our speakers for their thoughtful comments, and thank all of you for participating in the webinar. Again, the report and an audio of today's webinar will be available on our website, and thank you very much.